Task, conditions, standards. Task, to clean the swamp. Conditions, given a den of iniquity in Virginia's 8th Congressional District, the least religious but also most educated congressional district in the nation, and the strongest Democrat Party district in the Commonwealth. Standards, to prosecute corruption by presenting evidence that establishes guilt for criminal conduct beyond a reasonable doubt. Under the Federal Criminal Code, codified at 18 U.S.C. Section 201, C as in Charlie, whoever directly or indirectly gives, offers, or promises anything of value to any public official for or because of any official act performed or to be performed by such public official shall be charged with the misdemeanor of providing a gratuity and be fined under this title or imprisoned for not more than 2 years or both. At a minimum, this federal job offer that was received by a congressional candidate just days before the filing deadline for the Republican nomination convention in 2016 constitutes a misdemeanor of a gratuity because it is a thing of value offered to a congressional candidate and under the provision of the Hatch Act codified at 5 U.S.C. Section 7323, Parent 3. Any federal employee is prohibited from running for the nomination or as a candidate for election to a partisan political office. As an impeachment expert in Virginia's 8th Congressional District, ask yourself who would offer a gratuity to a congressional candidate in 2016 in Virginia's 8th Congressional District, especially one seeking the Republican nomination. We asked Congressman Don Beyer and Senator Tim Kaine, and they told us to make peace with ourselves. As an impeachment expert, ask yourself who had the power to persuade or influence an office in the Department of Defense to do so. We asked Congressman Don Beyer and Senator Tim Kaine, and they told us to go away. Under the Federal Criminal Code, codified at 18 U.S.C. Section 201 B as in Bravo, whoever directly or indirectly, corruptly gives, offers, or promises anything of value to any public official with intent to influence any official act, to commit or aid in committing or collude in or allow any fraud or do any act in violation of the lawful duty of such official or person shall be charged with the felony of bribery and be fined under this title for not more than 3 times the monetary equivalent of the thing of value, whichever is greater, or imprisoned for not more than 15 years, or both, and may be disqualified from holding any office of honor, trust, or profit under the United States. The only jurisprudential difference between a misdemeanor gratuity and a felony bribery in court is the establishment of proof and evidence beyond a reasonable doubt that there was a quid pro quo exchange agreement or this for that, which can only be found in an expressed or implied agreement. For purposes of prosecution, this element of agreement is most often found through strong circumstantial evidence, which until June 7th, 2019 did not exist. While there was clear and convincing evidence, usually sufficient for a civil action, there was not evidence beyond a reasonable doubt, the evidentiary standard of proof required to charge a crime, and also required to establish each criminal element in a civil action brought under the RICO Act. And all RICO actions require the existence of a conspiracy as defined by law. As stated in Marcantio v. Dudzinski, a conspiracy is an agreement between two or more persons to accomplish an unlawful purpose, or to accomplish a lawful purpose by unlawful means, which results in damage to the plaintiff through covert action done pursuant to that agreement. As stated in U.S. U.S.V. Andelcheck, direct evidence of agreement is unnecessary. Proof of such an agreement may rest upon inferences drawn from relevant and competent circumstantial evidence, ordinarily the acts and conduct of the alleged conspirators themselves, as stated in U.S.V. Murado. Additionally, once the conspiracy has been established, the government need only show slight evidence that a particular person was a member of the conspiracy. Of course, a party to a conspiracy need not even know the identity or even the number of his or her confederates. As stated in U.S.V. Heard, a defendant is presumed to continue his or her involvement in a conspiracy unless he or she makes a substantial affirmative showing of withdrawal, abandonment, or defeat of the conspiratorial purpose. In order to show the withdrawal, the defendant must show that he has committed affirmative acts inconsistent with the object of the conspiracy that are communicated in a manner reasonably calculated to reach conspirators. Mere cessation of activity in furtherance of the conspiracy is not sufficient to show withdrawal. As stated in U.S. v. Clemco, the government may prove the defendant's knowing participation in a conspiracy through circumstantial evidence, including 1. The defendant's association with conspirators in furtherance of the conspiracy, 2. His or her presence at critical stages of the conspiracy that cannot be explained by happenstance, 3. His or her possession of items that are of essential significance to the conspiracy, and 4. Acts that show a consciousness of guilt, including false exculpatory statements. A motion to dismiss, filed by the Merit Systems Protections Board, to quash a prosecution of what is at least a misdemeanor implicating both Congressman Don Beyer and Senator Tim Kaine for criminal conduct over 3 years old, indicative of itself of some suspicious behavior that has been denied, establishes their association with this conspiracy. Their presence at critical stages confirms their possession of significant items essential for the conspiracy, and their false exculpatory statements demonstrating a consciousness of guilt in what now has been established to be a felony, from which, as required under U.S.V. Heard, they have at no time expressed even the slightest indicia of disassociation or remorse, even when specifically requested and advised by the victim to do so. Moreover, even in present litigation, both Congressman Beyer and Senator Kaine continue to incriminate themselves in additional felonious conduct, to include exerting undue influence upon a federal agency, a violation 18 U.S.C. Section 207E as in Echo, Parent 1, Parent A as in Alpha, 2, Parent B as in boy. conduct punishable by up to 5 years in prison and or fine up to $50,000 or the amount of the compensation involved, whichever is greater, under 18 U.S.C. Section 216. Both Congressman Beyer and Senator Kaine continue to evade prosecution, obstruct justice, and pretend that nothing has occurred by spoliation of evidence, blocking on social media, and blackouts in the press. At least Senator Kaine has shown the wisdom to retain the best political law practice in the nation to defend against these allegations, unreported in the press. So, the effort to clean the swamp continues in the shadows of the courtrooms, and it is important to note that regardless of which crime has been committed, both the misdemeanor of gratuity and the felony of bribery are sufficient to support a finding of one of the two required racketeering activities to support a civil action brought under the Racketeering, Influenced, and Corrupt Organizations Act. The only further question for Hillary Clinton and others that may also be involved in this criminal enterprise is how much did the president know, and when did he know it? I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. Not unmindful of the future is the motto of Washington and Lee University. My name is Major Mike Webb, and I am running for U.S. Congress. In liberty, with honor and excellence, the South shall rise again.
This advertisement was authorized by Mike Webb.